Hi everyone, how are you? Hope you're all doing well. Welcome to part 32 of my narrated series of the 7M or LA case as it is currently being referred to in the scuttlebutt in the community. I looked today and I didn't realize that I've done 467 videos. So I know that I've gotten digs that all I do is Katie Joy. Well, I've done 467 videos in the year and a half I've had my channel. And this is my 32nd, of which there's 31 videos of Katie Joy. So that's less than 10%. So there's a lot of stuff in my channel here. I have everything in playlist form. I tend to do this, go really deep in one topic and go down the rabbit hole, slither around as much as I can, figure what I can out, and then dig myself back out, zip up that playlist, and it's done. And I move on. Of course, when I do lives, which I haven't done for quite a while, and I need to, everybody is welcome to ask me any question about any of the stories I've covered or anything I've mentioned. I don't have moderators or anybody else who works with me on this channel, so my lives are very much dependent on the people who enter the chat, as I like to include every single person who is in the chat and see what they're saying, and sometimes that can be really, really fun. So I plan on doing more lives soon, as soon as I'm ready to button this up, because here we are to the very end. We're in the little jaunt here, because this is all we have left to catch us up to where we are. So this little bit where I've reorganized everything. We did the review through here, went back to make sure that, so anything that is referred to in the original and amended complaint that is referenced in the upcoming hearing, that we are up to speed with, as well as basically everything that has been filed since, well, let's see, where are we at? So through June, May. Do I have anything from? So anything that was outstanding still coming through, as looking through the May, June, and July. So we still have a couple more things that were filed in that 7/11 date, and then we have a 7/20. We have two 7/25. So we have Jennifer Moore and another Amber, and an update in the motion. So from there, what I will do with the 7M case is just watch for when there are hearings and continue to check and see if anything has been filed, and then just add little updates as it is. And like I've said, I am going to do a couple more things with the Katie Joy thing, just because I think they're so relevant. There's a lot of things that just are not true, and I didn't even know. Like I say, and as many people that were covering the Katie Joy stuff, I had no idea of what was truly going on until I looked myself. And I hope that I have helped some of you see really where we're at, and maybe hopefully my my being able to shed some light on what is really happening here, as our local courthouse is a little bit different than anywhere else in the free world. But anyway, I am drinking Stress Balance tea. I dealt with a very stressful situation last night. I was just ready to go to the Trace Adkins concert and have a good time, and got a phone call that was rather upsetting, but messed up my sleep schedule, and so didn't sleep, and took me a while, but then I finally got some sleep and got up and worked out and did some housework, and gonna wrap this up. And so it says to add 2 tea bags for 8 ounces. So this is 12 ounces. So I put four tea bags in, hoping they'll really get that stress balance going. And I've I told my husband, I said, just really in the way that, I was looking at this tea box as the solution, stress response, in that we really need to look at how much addictions and people who are addicted and pills, as to how, the whole 80s culture and whatnot taught the new generation to handle out of control emotions by pills. That, narcotics would provide that little bit of euphoria to make you feel like everything is going to be all right and you can cope with things. And hand in hand with that is the Xanax. And then the people who, use the Xanax and the pain meds together, then, they don't have stress and a little bit of, put them in a better mood. The generation before that, was purely just alcoholics, and alcohol was there to cover those uncomfortable emotions. And as I have never been one to go to those places, I work hard on handling my emotions through workouts and tea and trying to breathe deeply. But you know what? Some things are just so complex. It has nothing to do with the channel, just so you guys don't worry on that. But just sometimes as you grow older, as you have to learn to pick your battles and kind of let things happen, as opposed to go to when you're 20 and you go and you tear down every wall until you find the answers. And as you get older, you realize that doesn't always work, and you have to sit back and allow people to be responsible for their own emotions and actions. And it's tough. Life is tough, but let's just hope that this is going to help with my stress a little bit. But if not, then I'm going to have to go work out again. I have to keep hitting it until I don't have those little feelings of, when you're anxious and you just have that uncomfortable feeling. It just goes through you, and kind of like electricity, especially when you're just like saying, okay, I've got to get to sleep because I've got to have this happen, and I've got to get up for this, and I've got to do that. But anyway, Trace Adkins was really good. Just a little side note. It's the second time I've seen him this year. I saw him earlier in the summer, and then now. So the Badonkadonk song is just in my head like you wouldn't believe. So anywho, we are here to part 32, and that brings us right back here to the 10th Judicial District Court, state of Minnesota, County Wright, with our plaintiffs being 7M Films Incorporated, with Robert Shin, Miranda Derrick, and James Derrick as the plaintiffs, versus Catherine Mansky Paulson, aka Katie Joy, and Without a Crystal Ball, LLC. They are the defendants, which, as we talk about, is silly because it's just her. And so much of this lore goes into Katie Joy and her employees and whatnot, or Katie Joy and Without a Crystal Ball. It's just all, that's just all Katie Joy. Maybe all of her and her personalities, but it's just really all Katie Joy. So this is a notice of motion and motion to compel discovery responses. And this is another well-written piece by Amber Stavig, I assume, because she does pretty good. So let's check it out. It says, two defendants, Catherine Mansky Paulson, a.k.a. Katie Joy, and Without a Crystal Ball, through their attorneys, Jennifer Moore, through Troutman Law, PLLC, 619 South 10th Street and Suite 201 in Minneapolis, Minnesota. And this notice of motion says, please take notice that at 9 a.m. on Tuesday, this is through Amber, okay. Yeah, that I was thinking, is this something that the judge wrote? No, that's right. They're saying when this is going to be. Okay. So this is please take notice that at 9 a.m. on Tuesday, August 1st, 2023, at the Wright County District Court, 3700 Braddock Avenue, room 1100, Buffalo, Minnesota, plaintiffs 7M Films, Robert Shane, Miranda Derrick, and James Derrick, plaintiffs, will bring on for hearing before Honorable Carrie Willis, Judge of District Court, their motion to compel discovery responses from defendants. Plaintiffs will and hereby do move the court at the above stated time and place for the following: for a motion to compel discovery response pursuant to 37.01 of the Minnesota Rules of Civil Procedure and other applicable law. This motion is brought pursuant to the Minnesota Rules of Civil Procedure and will be based upon the files, records, and proceedings herein and the supporting memorandum declaration submitted in accordance with the rules, together with such additional oral and documentary evidence as may be presented in connection with the hearing of this motion. And that was dated in that July 11th, 2023. And, these were all there for that hearing when the lawyers were to meet in person for the first time. And as we know, nothing happened, and they were granted a 6-week, basically suspend everything in motion to get caught up, and we have to assume they got there, but nothing has really happened, as we know. So we get past that, and the next thing filed is right here, and it is dated July 25th from Amber J. Stavig. Now, the next one will be also dated in that same, dated July 25th by Jennifer Troutman. So these are the two, and nothing further has been filed. As I double check and check back through the Register of Actions, and I reprinted it when I had everything, when I looked over everything to make sure that there was nothing else that was filed or available for me to see. There wasn't, and it's still just very much 29 pages of all of that. And so then that went to here, and it went to the same thing where it shows all of the filings, and all we have is just reflecting that that there in the affidavit of attorney, the other documents, etc., proposed order document, and the memorandums here in that 725. The 8.7 is order other. The 8.9 is just notice of filing order. 10.5 is notice of hearing, and 10.6 is order other. There, so I reprinted this, I think, on 11.1. That's all that there was. So we're not missing anything. Nothing has happened. There's not been any ex parte hearings. There's nothing. I mean, whatever happened in that phone hearing, we can only guess. It was supposed to be informal and just a basic, yes, I'm caught up. And that's that. Well, that tea is still hot. Very, very hot. Let's remove the lid so maybe I can drink that before the next New Year. Not this New Year, but the one after. I hope you're enjoying a beverage with me as we go through this. So, we got that there. And then we have over here again with our plaintiffs and our defendants, and we have the reply memorandum in support of plaintiffs' motion to compel discovery responses. So the introduction starts as defendants have failed to comply with discovery pursuant to Rules 33 and 34 of the Minnesota Rules of Civil Procedure. Plaintiffs have attempted to meet and confer with defendants regarding their deficiencies in discovery to no avail. As defendants have refused to comply with discovery pursuant to Minnesota Rules of Civil Practice 33 and 34, including a failure to provide a single document in response to plaintiff's requests, plaintiff's motion to compel discovery must be granted. That's what I'm saying, is that You can look back there, nothing's been filed, nothing's going on. They're not doing anything. The argument starts as defendants have failed to specifically address each of plaintiff's legal arguments and set forth a valid legal reasoning for their non-disclosure. As plaintiffs have met their required burden of outlining how the sought-after discovery is relevant and discoverable, and defendants have failed to establish that sought-after information is immune from discovery, plaintiff's motion to compel must be granted. And then here we go in stronger words here by Amber, where she says, defendants may not hold discovery ransom because they feel plaintiffs have not sent non-native format copies of defendants' own posts to them. Okay, so that's kind of where we had Jennifer Moore say, well, I don't know what to do, and some of those things, they don't work and they don't lead to anything when I put them in the computer, and I don't know, and then my client continues to post, and I went on vacation and I don't know. That's a little taste of how it's going down there. All right. Anyway, defendants claim that plaintiffs have stated in their Rule 26 disclosures that they have copies of defendants' social media posts, and because plaintiffs have not sent those to defendants, they are unable to respond to discovery. Okay. Lawyers need to seriously compel their client to cooperate. I'm going to say it in those terms. Okay? Defendants further state that they don't know which posts defendants deleted and which ones may have been deleted by Instagram. And that's exactly what it was, is that as Katie Joy likes to pull this, oh, I don't know, the dog ate the Bible. I mean, the dog ate my homework, kind of, I don't know, and not ever take responsibility. Her attorneys are playing the same game. They're kind of echoing what we see in her behavior, which is concerning because the lawyer should be leading the client to a resolution to make the alleged victims whole. In allowing the client to run the show, essentially, in this manner, can be problematic. All right. Now, the concept, like I say, the attorney says, well, I don't know. And then the internet gets rid of things and everything. And it's like, no, the internet's forever. And then it says, with regard to defendants' claim against plaintiffs' disclosure, defendants are required to respond to discovery in the questions asked. Plaintiff did not include specific posts, but specific statements by defendants. If this were a defamation case regarding oral statements of which there was no social media evidence, defendants would still be required to respond to discovery regarding why and if a statement were made by them. Further, all of defendants' posts were created, uploaded, and serviced by accounts directly in the control of defendants. Defendants may at any time request their own data from Instagram for any posts, lives, reels, or messages which have been taken down or archived. I didn't know that. But apparently there must be a process to do so. And then the channels which were cited as being hers are also a legal document. Somebody asked me about that the other day, so this kind of dovetails into that, and I wanted to show that really quick as someone asked me, so I found it, and it says, Defendant Katie Joy runs and uses various social media usernames on various platforms, including but not limited to. And this is where we have the ones listed, but we know that she has more. Okay, so it has Without a Crystal Ball, Colts Yuck, Exposing 7M, Without a Crystal Ball on both YouTube and Facebook, and Without a Crystal Ball Official, and Katie Joy Without a Crystal Ball on Twitter. So she has 2 Twitter accounts, and Without a Crystal Ball on TikTok. So that's 3 Instagrams, 1 YouTube, 1 Facebook, 2 Twitters, and a TikTok. How does anybody have time for that? I don't know how anybody has time for that. Don't you have... Don't you have priorities? There you go. How about that? How about instead of attacking anybody who actually mothers their children and has children, you pay attention to your own child. I gotta stop it. I slapped myself. There you are. Okay. All right. Okay. I gotta collect myself. Defendants may at any time request their own data for Instagram. Okay, blah, blah, blah. Now it says defendants may at any time request their own data for Instagram for any posts, lives, reels, or messages which have been taken down or archived. And you know what? I want to know about this because I had my Instagram that I'd had forever. And it got hacked, spam, whatever, to where I couldn't log into my Instagram account. And I had all my pictures and stuff on there that I've had for years. And I can't get into it because the original email where I started it was like an old email from yesteryear that I don't even have or have the password to. So without that, and I tried to get through to Instagram in every way that I could, to no avail. And so I would love to be able to say, hey, Instagram, I want to access everything that I've done, my pictures and everything. So I wonder how that is done. I'm going to have to put a little star there to find out. I mean, what a learning experience this is for everybody involved here, including myself here. There we are. Tabitha Jane is getting smarter by the minute, aren't I? Mm-hmm. Okay. And it says, as all of defendants' posts are solely within the control of defendants, stating that plaintiffs must provide whatever screenshots or screen recordings they may have in their possession before answering any discovery is an attempt to prolong litigation and evade answering the questions. Oh, calling out the behavior here right on. I like that. Take a bow, Xena Warrior Princess. Amber Stoffig. Anyway. Defendants have provided no evidence that anyone other than defendants are responsible for deleting or taking down posts. Defendants have not provided emails from Instagram stating that a post was taken down for violation of their rules and guidelines, nor have they provided any evidence to support their contention that Instagram's addition of reels to their platform somehow deleted defendants' posts. Oh, so that's her story, huh? And she's sticking to it. That's her story, and she's sticking to it, maybe? Maybe. We'll ask the crystal ball, could that have happened? Crystal ball, could that have happened? Could this be possible? No response there. What about from this one? The crystal ball tells all. Saying what? It's saying what? It's a bullshit. Ah! And there I am, the witchy poo says, oh, yep, we all say bullshit. Okay. Hoping for a better result there with that stress response always, but here we go. Drinking the tea, drinking the tea. Defendants must answer relevant and discoverable discovery requests and provide to plaintiffs all information within their control. The Free Flow of Information Act does not apply to defendants, and therefore defendants must answer plaintiffs' discovery. Ooh. Minnesota Statute 595.023 provides. Well, maybe I should have done this backwards, because maybe Jennifer Moore's response has some of these. Live and learn, live and learn. Because I've not heard that argument come up before, that the Free Flow of Information Act. Let's check that out sometime. The Free Flow of Information Act. Interesting. Except as provided in Section 595.024, no person who is or has been directly engaged in the gathering, procuring, compiling, editing, or publishing of information for the purpose of transmission, dissemination, or publication to the public shall be required by any court, grand jury, agency, department, or branch of the state, or any political subdivisions or other public body, or by either house of the legislature or committee, officer, member, or employee thereof, to disclose in any proceeding the person or means from who or through which information was obtained, or to disclose any unpublished information procured by the person in the course of work, or any of the person's notes, memoranda, recording tapes, film, or other reportable data, whether or not it would tend to identify the person or means through which the information was obtained. Interesting. So just to pull that over, because that ended on that thing. So let's say here, so we're going to go Minnesota Statute 595.023 is right there. So we know, since that went over there, we'll do a little arrow here. And it says defendants do not qualify for privilege pursuant to Minnesota Statute 595.023, as they have stated that they are not in the business of sharing information, but in sharing opinions. Oh, using her words against her. I like your style, Ms. Stavig. Okay, and it says, see defendants' responses to plaintiff's interrogatories, request for production of document, request for admissions, and defendants' answers. Okay, so in sharing opinions. They're not in the business of sharing information, but in sharing opinions. Doesn't that just sound like something that she'd say? She's such a twat. There we go. All right. There we go. Defendants' own opinion do not qualify as information for the purposes of the statute. Minnesota Statute 595.022 specifically states only news media should have the benefit of the privilege to not reveal sources of information. There we go. This word not is the biggest word in this page. If opinions qualified for immunity under this statute, every single person who has a public Twitter account would be exempt from disclosure of information in a lawsuit. Anyone who wanted to avoid being deposed or held responsible for a statement would merely need to send a tweet, and they would automatically be exempt from disclosing any information related to that subject matter. As defendants themselves have stated, their statements are merely their own opinion. They cannot simultaneously claim that they are reporters and have qualified immunity for reporting facts. If defendants are reporting facts, they must state so and retract all statements that their posts about plaintiffs have been merely their own opinions and not statements of fact. And that right there, a disclosure stating that, would probably have went a long way in stopping litigation. Would people still listen to what she's saying, and would she still have the platform? Yes. People don't read the fine print. They don't care about if you have something that says, this is my own opinion, blah, 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 blah. Especially if she had it like written in there as, I bring back, especially with the Watts, I was very, very careful in showing that, some things needed to be connected from fact to story to show how this could have plausibly happened in ways that do not make sense. I was trying to make sense out of nonsense. And I, was always careful to cover myself and say that this is for entertainment and educational purposes only. Some things may be true and some things may not be true. And you got to do your own research and figure out which ones. So if she were to turn around and change her ways and put things like, it's my opinion that, or I saw that when somebody else brought action towards them, they accused them of this type of behavior on this date. Something like that. But that's what a responsible person would do, journalist or not. Anywho, I can't believe that people listen to her or give her a platform as it is. And if they didn't, there wouldn't be any problems. She'd just be somebody talking out of their ass from some little tiny Midwestern town that, she lives in a town that doesn't even have, I can't even describe it. It's so small. Just like a little suburb. Beautiful area, though. Really is. Very beautiful. Minnesota Statute 595.025 states, the prohibition of disclosure provided in Section 595.023 shall not apply in any defamation action where the person seeking disclosure can demonstrate that the identity of the source will lead to relevant evidence on the issue of actual malice. Okay. That's interesting. Even if defendants' statements do qualify them to be covered by Minnesota Statute 595.023, plaintiffs have pled actual malice against defendants. Oh. Further, without obtaining information and the identity of these individuals from whom defendants obtain their information with regard to the statements made about plaintiffs are completely unable to prove that defendants made their statements without proof. No other person or entity posted or distributed the statements made by defendants prior to defendants' social media campaign against plaintiffs. Excuse me. All material requested is relevant to plaintiff's claim for defamation, as it will show the information was credible if the information existed in the first place, and if defendants lied or exaggerated any information given to them. Plaintiffs have no other way to obtain the information sought, as defendants were the first ones to post false and defamatory material about plaintiffs and have been named as a source by almost every news article which has republished their false and defamatory statements. So they're showing that there are the secondary and tertiary consequences of her actions, and it all goes back to her, and they're saying, okay, shit slides downhill, so we're coming to you. That this one sold you out and said this is where they saw it, so where did you find it? And she's like, I don't have to tell you. I don't have to tell you because I'm a journalist. I've got journalistic privilege. It's like, she watched a TV show where somebody, goes and claims diplomatic immunity after they went and whacked somebody. What? What is she doing here? On what planet do you not think that you need to take responsibility for your actions and behavior? That's not a very good example of mothering, of no, shut up. Defendants have failed to establish that the sought-after information is immune from discovery, such as defendants must respond as requested by plaintiffs. Requests for production of documents. Defendants have failed to produce a single document to plaintiffs. Defendants are required by Minnesota Rules of Civil Procedure 34 to produce all relevant and discoverable information sought by plaintiffs. Requests 1, 4, and 5. Defendants must answer discovery. Their discovery responses are not to be held for ransom until plaintiffs provide defendants with their own posts, which plaintiffs have already provided direct links to. Okay, I really like this because this is, like I say, and I mean it's well illustrated when we see the manipulations, in my opinion, of Jennifer Moore saying, "Oh, I don't know what affiliate means," or I don't know what that could possibly mean. You know damn well what it means. You're just playing games to delay the process. And this is part of that where, well, I don't know where those posts are. Well, it doesn't matter if you don't know where they are. They were documented. She was told not to destroy anything. If the link doesn't link to anything anymore, that the point is moot. It doesn't matter. It's already documented. It's there. It's proven that it came from her. If it goes to trial and they have to have a representative of Instagram or Facebook and each of them to say, okay, yes, this was generated at this point by this person with this ISP that traces back to this address at this time then they'll do it. Going to trial would not, in my opinion, be favorable for her. But what do I know? Sipping the tea. Defendants must provide copies of all documents referenced in their response, even if that document comes from a lawsuit one or several of the plaintiffs were parties to. Plaintiffs have the right to inspect the copy of the document that defendant actually utilized. Now, this is where we saw that, indeed, Katie Joy is known to pull documents off of old court filings on people. And I mean, if you think about it, if you're a person who's been divorced, I've been divorced. If you were to go back to, well, my divorce is pretty friendly, so there's not anything that anybody would find in that way. But let's say that somebody has a contentious divorce. People write things when they're angry and they're fighting and whatnot, but then those are put on the record for this and that. Is it right to then act like what somebody else has said? Well, they have very strong feelings about an issue. Is it correct to then use that as a fact? Or is it correct to say that during a divorce, their ex-spouse claimed that they did this? That's how you do it, but not Katie Joy. And it says defendants must answer discovery. Their discovery responses are not to be held for ransom until plaintiffs provide defendants with their own posts, which plaintiffs have already provided direct links to. Defendants are required to comply with the document request, even if most of the social media posts are online. Plaintiffs have defined affiliates, and defendants are attempting to evade the question by not understanding the dictionary definition set forth by plaintiffs in their pleadings. Request number 9. Defendants have not addressed, hello, baby. Hello, hi, honey. Hi. Hi. What are you doing? Hi, Boo. Oh, honey, you're right where I need to be, sweetheart. He wants me to come to bed. He's cold. He's been very cold, and so I have served as his incubator. And he has been very, very funny lately because today when he decided it was time for me to get up, he decided to put my hands down so I couldn't continue to pet him and try to take off my CPAP with his mouth. Didn't you? Didn't you, Boo? Didn't you, Boo? What are you doing? You're sitting right where I'm talking. I know. This is his bedroom, the guest bedroom. And I am in his space. But I thought that if I did this, this would work better for him so he can just fall asleep next to me when I'm talking. Because he gets really mad when I'm at my desk. Because we don't have a chair conducive to our love. Boo, you can move, baby. You can move. Can you move over just a little bit with your butt, please? Your butt's right where I need to be, honey. Oh, I gotta brush you. You got hair going all over. This light's really showing it. Yeah. What are you doing? Can you move? No? Not at all. All right, let's see. Are you going to hold me hostage here? I've got to get you something. What do I got to get you? A treat? Oh, I don't really want to say the word because then you're going to jump up. Yes, you will. Yes, you will. Sweetie, I got to get you the paper. Can you come over here? Can you move? Here, come over here, honey. Let Mama get you the paper, okay? Please. Can Mama have a hug? Oh, thank you, baby. Thank you, Boo. Oh, you can't jump that way, honey. There's no way. Oh, there you go. Thanks, baby. I love you, Boo. Thank you, Boo. I love you. Come up and take a nap. Come up here. Come up. Take a nap right next to Mama. Come on. Come on. He fell asleep there last night. I didn't want to wake him up to take him to bed with me. But then it was like 4 and he hadn't came over yet. And I was like, oh, I just needed him. I whenever woke him up, he's like, oh, like he didn't mean to sleep that long. It just happened and didn't know what to do. And he's so funny. Boo, you can come back over here. I move things for you. Come here. Sorry for the cat delay. Having a cat coworker is, that's one of those things. These things happen. Boo, come back. Okay. So, where were we? We were back to saying that defendants are required to comply with the document request, even if most of the social media posts are online. Like, how flippant and unprofessional is that to be answering? I mean, this is very serious. We're talking about $40 million at stake here. And they want to be unprofessional, flippant, otherwise twatty. Tisk. Let's see here. And I mean, this may be one of the biggest reasons why I'm not an attorney, because I would probably just call people twats all the time. Okay, request number 9. Defendants have not addressed plaintiff's legal argument regarding request number 9. Defendants have not addressed plaintiff's legal argument regarding request number 10. Requests 11 through 24 are: defendants have not addressed plaintiff's legal arguments regarding requests 11 through 16. And then we go to the interrogatories. Interrogatory number 2 states that defendants have failed to answer this interrogatory with individuals who may have information related to this lawsuit. Defendants have stated that certain posts contain names of person who provided information, but have not specified that information. Defendants are required to provide answers to interrogatories pursuant to Minnesota Rules of Civil Procedure 33, simply stating that the information sought is somewhere on defendants' various social media platforms is an insufficient response to this interrogatory. Further, defendants have not stated that one or 5 people provided them information and they are protected by journalistic privilege. Defendants have not provided a privilege log. They are simply stating that we have sources and you don't get to know how many, who they are, what information they provided, or even if the information provided was true. I mean, oh, I can't even. I mean, it's just not how you freaking behave as an adult. And an adult being sued. Again. I mean, this is a good argument. I want a pickle right now. I don't know why. I don't really think of pickles often. Just kind of want a pickle. I don't know. Anyway. Don't they say if you crave pickles that you're dehydrated? I'm not pregnant, so anything other than that. This is just funny, the way this is. Because you can hear it verbatim while they're trying to make their answer to it is that defendants have not provided a privilege log. Okay, so that's a good argument too, that okay, so if you have privilege, then okay, well where do you have this listed at? You know, that they are simply stating that we have sources and you don't get to know how many, who they are, what information they provided, or even if the information provided was true. This interrogatory does not request merely alleged journalistic sources, but anyone defendants believe have information relating to this lawsuit, including persons defendants have provided information to. Defendants must answer this interrogatory. And I mean, I know how that feels, that when you are falsely accused of something, you want to get to the bottom of who's saying what, when, where, and how. And when you get that, you try to show that the information is this, and that this person said that, and this was the ensuing result. But often the damage is done, and people go to their respective corners and take the information with them that they already heard it, and they don't want to know that they are wrong or that the person who told them that was wrong. And it's really frustrating. Once people have heard it, the damage is done. Interrogatory 6. Defendants have continued to fail to address plaintiffs' valid reasoning for their objection to answering discovery. As defendants have completely failed to even provide one fact, such as the statements made by Ms. Paulson are all true, they have failed to answer this interrogatory. Okay, so they're saying, as defendants have completely failed to even provide one fact, such as the statements made by Ms. Paulson are all true, like that's an example of it, they have failed to answer this interrogatory. Defendants' contention that they may obtain the requested information through a deposition is irrelevant. Plaintiffs for defendants to provide information which supports their denials in their lawsuit, as this is relevant and discoverable information. Defendants must answer this interrogatory. Further, if defendants are stating that defendants' attorney at the time did not have sufficient information from defendants to provide a proper answer to plaintiffs' amended summons and complaint, they are admitting that Mr. Martin violated Minnesota Statute 549.211 subsection 2, 3, and 4 by presenting claims, defenses, or other legal objections warranted by law, allegations, and factual contentions without evidentiary support, and denial of factual contentions which were unwarranted. If this is the case, sanctions against defendants and their attorney is warranted for presenting information to the court in violation of Minnesota Statute 549.211. Bam. Oh my God. They finally got there. That is huge. Whoa. And this has been there since July, but I just didn't know. I had no idea, because I was wondering at what point they were going to look at this and say, you know what, you're behaving so irresponsible. Your behavior is so irresponsible by representing your client, by acting like what your client says is law rather than what is law, that your defense is going to put you in contempt, and there's going to be a complaint against your bar license. Oh, wow. Her attorneys must be getting pissed. If I had ever done anything that got my attorneys, oh my God. This is huge. That if I was an attorney and I got this, I would, like I say, shit goes downhill. So you get shat upon, you shat on somebody else, and shit goes downhill. If I was this attorney and I got this, I would call up Katie Joy and be like, look at what your freaking behavior and dragging your feet has gotten me into. Right now, I am looking at facing sanctions, and I could get a complaint against my license. That this is threatening my career, and as we know, they are eclipsing on their retirement, to be at that position where they're going to have to answer to what they're doing. That's something else. And that's really where, we saw Graham, Mr. Martin, be pivotal in the earlier complaints. And then we see Jennifer Moore take over. And Jennifer Moore can't keep up or get up to speed. You have to wonder, did Graham have this situation going on and Katie Joy wouldn't comply? And he said the words like, you need to do this or we're all going to be in trouble, and I don't want to be taken down because of this. I could get in trouble. And she still wouldn't comply. So he was like, you know what? I'm not taking on this case any further. I'm going to withdraw from the case if you don't. And that's where Jennifer was like, hold on, let me take a look at it. I, have a PhD in dealing with twats, and so let me see if I can really help. I'm sorry. I just see a lot of twatty behavior out of Katie Joy, and I cannot hold back anymore. I can't be professional. I'm to the last few pages of this, and it's time to just call this as for what it is that Katie Joy's a little twat. And as you know from my Watts coverage, I had the sign in the beginning. I said, no twats, no T-Watts, no twats, because in Europe, they call people twats all the time. It's just if you're being stupid, you're a twat. Well, that's what's going on here. And it's just, you just see her behavior, and she's a freaking twat, like a blue twat waffle, a complete twat. Clearly the tea malfunctioned and didn't take my stress away. It made me just start calling people twats. Oh my God. I can't believe that. To put an attorney's and in the legal world, as you all know, attorneys are friends. They go to the same social places that other attorneys go to. It's not that they are unfriendly towards each other. They put things away. So for one attorney to come to another attorney, this is big. This is a very big thing. This is really saying that there is a problem and that there is not a quick and easy solution to this problem. as we see it as a continued problem. And in a trial or whatever, you can't refer to previous litigation unless it is brought in, and then it would be brought in as to why it was thrown out, what was in it that was problematic, etc., etc. So it's not like they can introduce that without there being a fight, because if it comes down to a trial and you have a jury selection, which, like I've told you, people out here really don't know her, so it would be no problem to find people who don't know. But they wouldn't necessarily know that this is a continued pattern unless it's brought in. And I know that if I were 7M, I would argue to have the pattern of consistent behavior brought in, but her attorneys would say those lawsuits were never confirmed. Well, they didn't ever prove any. They were. I mean, we know all of the different little reasonings and why this didn't go there, blah blah blah. We know that it's stated in here in the complaint that there are other open lawsuits, because at the time there was, but there isn't now. So that would be definitely something that they would argue back and forth. And if you were a juror and you didn't know that there was a history of past behavior similar to this, I think that would be a very big consideration in how I would make my decision on whether or not this was intentional and problematic. Anyway, interrogatory 7. Defendants have failed to answer this interrogatory or state how requesting defendants to identify all statements they have made about a person or entity from January 2020 to the present is overly broad. Okay, so defendants have failed to answer this interrogatory or state how requesting defendants to identify all statements they have made about a person or entity from January 2020 to the present is overly broad. Further, they have failed to address how defendants making up statements or lying about a person or entities is not relevant to this lawsuit. As defendant lies and unverified, as defendants, okay, this was messed up again. As it says, as defendants lies and, okay, there we go. As defendants lies and unverified statements of fact about anyone is highly relevant to this lawsuit, defendants must answer this interrogatory. Okay. Interrogatory number 9. Plaintiffs requested the number of followers purchased by defendants from January 2020 to the present. Defendants objected on the basis of relevance, but have not provided an explanation as to how purchasing followers is not relevant to defendants' self-proclaimed status as a journalist, or to the extent of the dissemination of her false and defamatory statements. Defendants' purchased social media followers are relevant to this lawsuit, and as such, defendants must answer this interrogatory. Okay, and now there's this little footnote here, and that goes over here to where Mr. Martin has, so it has a little 1, so this is a little footnote here, where it says defendants' response memorandum states that Mr. Martin signed defendants' answer, when in fact the answer was signed by a Ms. Kristen Hendrick, bar identification number, 0395049, and dated September 2, 22. So they're looking at bar qualifications and who they're probably looking and seeing if they've had previous complaints against their bar license. Wow. Interrogatory 11. Plaintiffs requested defendants provide the name, address, and contact number of each person who provided defendants with information regarding plaintiffs. Defendants objected as protected by journalistic privilege and stated where relevant sources were named in the posts. Defendants are required to provide the names of all persons in their social media posts. Informing defendants to look at their posts without even providing copies of the posts is not a sufficient response to this interrogatory. Interrogatory 12. Defendants did not respond to plaintiff's request regarding Interrogatory 12. Interrogatory 14. Defendants have stated that their contact with Melanie, Dean, and Kelly Wilking is related to this lawsuit. As such, defendants must provide all information provided between defendants and the Wilking. Doesn't have an S. The Wilking. Interrogatory 15. Defendants have failed to provide case law addressing how defendants' status as an informant to others regarding the defamatory statements is protected by journalistic privilege. Defendants are required to provide plaintiffs with all statements provided to third parties about plaintiffs as the basis of this lawsuit is that defendants have repeatedly engaged in sharing false and defamatory information with third parties regarding plaintiffs. As defendants have been named as a source in several journalistic outlets, and there are no statements regarding plaintiffs predating defendants' social media posts, defendants' contact with reporters relevant to this lawsuit. Okay. Interrogatory 16. Defendants claim that they are not obligated to answer for any statement other than those enumerated in the amended complaint. Plaintiffs also stated in their amended complaint that defendants were continuing to engage in a campaign of defamation and that all future statements defendants made would be included in this lawsuit. Further, statements made to third parties about plaintiffs are highly relevant to this lawsuit as it may prove the truth of falsity of the statement made by defendants, defendants' motive in making the statements, and if defendants made up the statements without any information or sources at all. Bam. Perfect. Oh, I bet you that Amber graduated at the top of her class. She's just so smart. Okay. Interrogatory 17. Defendants have repeatedly in both social media posts and comments stated that plaintiff Robert Shin was engaged in human trafficking. If defendants did not make this statement, they may simply state so. If they did make this statement, they must answer the question. Plaintiffs are not required to provide the exact post and a link to it, especially given they have already provided this information in the amended complaint and defendants have since deleted the posts. Interrogatory 18. Defendants did not respond to plaintiffs' request regarding Interrogatory 18. Interrogatories 19 through 23. Each interrogatory includes a statement made by defendants. If defendants did not make the statement, they may simply state so. If they did make the statement, they may provide the information requested. And in Interrogatory 24, defendants have not answered the interrogatory requested. The interrogatory asks what information was provided to defendants and for each fact or statement to provide the contact information for the person who provided the information. No information has been provided by defendants. No name or contact information has been provided either. Defendants must answer this interrogatory. Interrogatory 25. Defendants have made a post on social media with the statement made in Interrogatory 25. There is no requirement that plaintiffs show defendants a copy of their own statement when asking about the information related to the same. If defendants did not make the statement, they may simply state that. If defendants did make the statement, they must answer this interrogatory. Interrogatories 27 through 36. Plaintiffs asked what information was provided to defendants regarding the statements, various social media posts, news articles, and a link to defendants' own posts are not sufficient answers to this interrogatory. As such, Defendants must answer the interrogatory in full. Interrogatory 37. Defendants have not specified what information was provided to them to support their statements that Robert Shin curses people that do not donate to him. Mr. Shin testified to this effect in a deposition conducted in Ms. Chung's lawsuit. Is not a full answer to this question. Defendants must state specifically what information was provided to them regarding this statement. Interrogatory 38. Defendants have not fully responded to plaintiff's interrogatory. If defendants are referencing an audio statement of someone as to their answer to this interrogatory, they must state that. This interrogatory may reference is an attempt to avoid answering the question. Oh, I love how Amber calls out the manipulation as it is. Interrogatory 39. Defendants have not fully responded to plaintiff's interrogatory, generally referencing a lawsuit, is not answering what information was provided about a specific statement. Defendants must answer this question. Interrogatory 40. Defendants are in possession of all of their social media posts and presumably have the underlying information regarding the same. The likely post in question is an evasive answer to this interrogatory, and defendants must answer the question affirmatively. Okay. Interrogatory 45. Defendants are still required to state the legal basis. Oh, whoa. Oh my God. They misspelled this. Look at this. Legal basis, B-A-S-E-S. Defendants are still required to state the legal basis, B-A-S-E-S, instead of basis. Because the next one is right, because it says basis here, it should be basis there, upon which their affirmative defenses rest. Okay. And then the period, and then this should have been capitalized. Oh, I would have gotten in so much trouble if I would have wrote like this. What the heck? Okay, so subject to attorney-client privilege is not a valid legal basis to assert a defense. Defendants are required to answer this interrogatory. Interrogatory 46. Plaintiffs have only asked 46 interrogatories. If it is defendant's contention that each denial is a separate interrogatory, they are still required to answer the interrogatory with respect to the first 5 denials. Okay. Conclusion. Defendants have failed to timely provide relevant and discoverable information requested by plaintiffs pursuant to Minnesota Rules of Civil Procedure, paragraph 33 and 34. Further, they have failed to outline a legitimate legal reasoning for their failures to respond. As such, plaintiffs' Rule 37 motion to compel full responses to discovery must be granted, and costs, disbursements, and attorney's fees shall be granted to plaintiffs for their costs in bringing this motion to compel. Take a bow, Ms. Stavik. Dated July 25th, 2023 by our hero here, Amber J. Stavik. And she has an address now in Meyer Street in Maplewood. There we are. And that, my friends, concludes episode 32, which then will bring us to 33. And we will be done and up to date with where we need to be for the hearing this week that I'm still trying to be able to fix so I can go. Otherwise, I'll just get the paperwork, and we'll be just kind of updating and on trial watch for this case. And Well, that's that, my friends. Thank you for listening. I really thank you, and it helps my stress balance to talk. I like to talk about things. I don't like to hold things in. So it is a stress reduction tactic for me to narrate. And I thank you for being on the other end, listening and providing me with more food for thought as we talk back and forth through the issues and kind of try to see why anybody would behave in the manner that they do, like Katie Joy behaves. It's a mystery, very much so. So thank you once again, and I will go and put Boo Boo to bed, and I will see you guys again in episode 33. Thank you. Bye-bye.